Okay, it is 6 o'clock. Let's get started. So, welcome to Estate Planning 101, where I'll be your host. My name's Xavier Davis, founder of Scarborough Law, and I'll teach you today how thoughtful planning can keep loved ones out of court conflict and confusion. Okay, so who am I, right? These are my credentials. I went to West Point, graduated in 16, did my 5 years in the Army as an air defense officer. When it came, got out, went to Georgetown Law, and then started this law firm called Scarborough Law. But why did I start this law firm in particular, and why did I choose estate planning? Well, I am someone who has experienced what happens when a bad plan is in place or a lack thereof. My grandmother inherited a home with her sister from their father, and they both were on title. The problem with that was that my grandma wanted to sell it, and my great aunt wanted to rent the home out, and they don't speak to this day. And that kind of stuck with me as I was going through law school. I said, "Hey, this is an important area of law. A lot of people don't know about this area of law, and it affects every single one of us. Every single one of us will deal with a death to our family members. Will know someone who has become incapacitated." And this is not easy stuff. Probate in Texas, it's one of the more friendlier probate states, but it's still, I mean, I get calls every day of people who their aunt has, they think their aunt has stolen their dad's money after he passed. They can't get their mom out of a nursing home when their brother admitted him to the nursing home. So they're asking me, how can I get my mom out of nursing home? She doesn't deserve to be there. What kind of documents do I need? All that is estate planning. All that is putting someone in place to care for you when you need it the most. So tonight is interactive. There will be polls. You don't have to scan this. We're just going to do multiple choice. Um, so moving on. So what is estate planning? Estate planning answers three basic questions. Who can act for you? Who receives what? And how do you make this easier for the people you love? The reality is estate plan is not really about you. Yes, you're the center of the plan, but your loved ones will be the one who feel the lack thereof, the lack of a plan thereof, or are going to have this, you know, um, deal with your estate after you pass. So right now, just take a second to think about who needs your protection, right? Because estate planning is going to be about those people who are relying on you to pay bills for them when you pass. Are they going to know how to access your accounts? Um, are your parents, depending on you to take care of them when they get older? So estate plan is not just about you, it's about who needs your protection. So I'd like to start with this story about this couple. I've been in practice for a little over a year now, and I've already dealt with a couple who already said that they're going to get estate planning. They swore up and down, like, I'm gonna get estate planning. I got your contact. I'm gonna schedule my life and legacy planning session. That's the first meeting that I give to clients. But they never got to it. And so he ended up passing in February, the husband. Um, and the wife, you know, grieved after the immediate passing, but eventually she had questions about how she's going to get access to her husband's accounts, right? Her husband had separate accounts, not joint, uh, you know, um, brokerage accounts that didn't have a beneficiary designation on them. And their home was, although they were both on title, they didn't have what's called the right of survivorship. So, in order to get her husband off of the title so she could sell the home, and she couldn't afford the home payment anymore, right? They both needed to help with the home payment. So, once he passed, she was stuck with the note. And before she could even sell the home, um, she has to go through probate and get him off a title, right? So she asks, can I access his bank accounts? Can I deal with the house? Do I have authority? Will the title company even let me sell the house? So she came in, she scheduled a life and legacy planning session with me. Part of that life and legacy planning session is we sit down. beforehand, and she completes her inventory. That's inventory of everything she owns and everything she thinks her husband owns, because they never did a total inventory of their estate. This is very important to do before someone passes. So at the meeting, we reviewed what they owned, how they were titled, who was named the beneficiaries on all their accounts, and what passes automatically according to either a beneficiary designation or a pay on death. A lot of separate accounts have pay on death uh, designations where you can avoid probate if someone uses that designation. And then we talked about what is she going to have to go to court in order to get complete authority over. And so a little multiple choice question for you guys. So, which asset is most likely stuck? Her husband died without a will or a trust. Which asset is most likely to require a court process before she can fully control it? A, life insurance naming her as a beneficiary. B, retirement account naming her as a beneficiary. C, joint bank account with right of survivorship. D, his interest in the home title in his name alone. Or E, you're not sure, right? Um, if you guys want, you can put the answers in the chat. If not, we can just move on. Give you guys a second to think about this, but um, okay. Denise says D, his interest in the home title in his name alone. Yes, the answer is D, right? Estate, and if you guys have questions, go ahead, drop it in the chat. I'll get to them either if I catch them while I'm talking or at the end. So the answer is D, title. So estate planning starts with ownership. You can only plan for what you have legal authority over. You cannot plan for your husband's property because he owns his property. Even though Texas is a community property state, you each own your half of the community property. So you can't even plan for your husband's half of the community property or your wife's half of the community property. Um, you own it together, right? Community property is it's wholly owned while you're both alive, but when you pass, it must pass according to your estate plan. And so that's what the wife's problem was. She was stuck. She could not plan for her husband's portion, and she obviously can't sign for him, and he's passed. So what did it cost the wife? It cost her time. It cost her money. Probate is not cheap and it's not time effective. She lost control over her life, right? She has to maintain this mortgage, uh, you know, through this probate process until she can get full control. And she lost a lot of sleep. I mean, it's very stressful to have to go through court and do this. And, it's just not worth it. So I put together this probate fact sheet for you guys. You can take a picture, screenshot, or whatever, that highlights the different pathways that you can go through probate. So probate is the process of getting title to something to settle in the state. And so we have this first pathway is called the affidavit of heirship, right? This is basically saying you don't have the person who died didn't have a will, and it's just for real estate. You the idea is you list all the heirs on this affidavit, and they sign saying this is true that this person died and owned and had these heirs, and you submit this to the title company, and they it's in lieu of a deed. So they file this at the county, and this is like your evidence that you own the home. A lot of title companies, though, won't sell a home if your claim to that property is an affidavit of heirship. Usually, they want to see about 5 years have passed since this was filed at the county before they will sell a home that you're claiming you own from an affidavit of heirship. So the next 4 or 5, pathways have to deal with court orders. If you go through this pathway, you will get a court order instead of just an affidavit of heirship, which is just a sworn testimony of the heirs. And so a small estate affidavit, um, you know, you're talking about $2,000 probably at minimum, to and even more expensive if you have to do a large inventory. That could take 2 to 3 months or weeks, 2 to 3 months, sorry, 4 to 10 weeks. The next one is probate as muniment of title. Notice that this is a valid will. All wills go through probate. Wills do not avoid probate. Wills are essentially instructions to a judge telling the judge what to do with your estate. And so if you have a will, you will be paying $3,000 for your spouse or your children to settle your estate. Uh, I'm going to give you a preview of the rest of this presentation. Don't get a will. You either want a trust or a beneficiary designation. That avoids probate, that avoids this whole cost sheet because after muniment of title, the costs actually start to become a little bit outrageous, right? So you're looking at like 3,500 plus and dependent all the way down to the last pathway, dependent administration. I mean, $8,000 is light. If you pass with no plan and you have a lot of assets and your heirs don't get along, you will be going through a dependent administration that could take, I mean, it'll take probably longer than a year. And you'll be paying the lawyers upwards of 15, probably $20,000 to go through that whole process. It's not pretty. You're constantly in and out of court. Um, so you want to avoid probate altogether. A big portion of estate planning is about avoiding probate. So this just rehashes you can only plan for what you own. That includes community property. You may share ownership during life, but your spouse's interests still need to transfer past that death. If there is no will, trust, survivorship agreement, or beneficiary designation, state law may decide what happens next. And that's what probate is. It's state law coming in and telling you how your estate will be settled. So this bottom portion is just ways your estate can pass to someone else. So you have a will, right? Know that that's still going through probate. You have a trust that avoids probate altogether, and follows your wishes. You have survivorship agreement, like a joint tenancy with right of survivorship that's commonly found on deeds in real estate. You have beneficiary designations. That's things like pay on death of bank accounts, life insurance designations. And then last but least is state law, right? And that is probate as well. So the middle three avoid probate. Will and estate law is probate, court, court process. And people don't wait because they're evil, right? People, it feels easy to postpone. Like you'll get off of this, webinar. Nobody's putting pressure on you to get your estate plan done. It'll just feel really bad on the people who are dependent on you when you pass, because I mean, in a sense, it'll be as if you didn't think about them while you were alive. Um, and so, you know, some people don't mind that, and some people do. I personally want everybody to not have to be grieved and also burdened by legal processes after I pass. And so this is another story of someone who thought a will was enough. Um, in their will, they said that they want their entire estate to pass to their children equally. But one major asset had a different instruction. Okay. The family assumed the will controlled everything, but the life insurance had a different instruction. So dad's will says everything goes equally to his children. His life insurance names one child as beneficiary. So you can imagine the life insurance policy, let's say it's $1 million. The rest of his estate, his property, his brokerage account, his retirement account, all that, let's say that's 500,000. So in his will, he says the $500,000 estate will go equally to his children, but he only names one child on his life insurance as his life insurance beneficiary. So the question I have to you is who receives the life insurance beneficiary, the life insurance proceeds? Is it A, all children equally because the will says so? B, the child name on the beneficiary designation? C, the executor decides. The executor is the person who probates the will. D, the probate judge automatically divides the life insurance. Or E, I'm not sure. So, what do you guys think? B. The child name of the beneficiary designation. That is correct, Denise. You're killing it. Great job, Denise. Yeah. So that specific child is going to get the $1 million and his portion of the $500,000. Um, and so that's going to put him in an odd place with his siblings. Obviously, the siblings are going to want, that sibling to divvy up that money accordingly, but he's under no legal obligation to do so. Even if he does decide he's going to, disperse the life insurance equally, the other siblings are going to be put in a position of either trusting that the sibling didn't lie about the total amount, or that sibling being forced to prove how much money he got. And it's just, it's unfortunate. Obviously, this is a mistake, but it's a costly mistake. It can really erode family trust. And this is not something that I know a lot of parents would not want to put their single child in that type of position, but it happens when you have a new child. Parents often forget to update these things, and so it's why it's so important to have a process in which you review it either annually or every 3 years. My firm does it every 3 years, right? When you hire my firm to do your estate plan, it's not just I give you documents, you go into the wind. No, we form a lifetime relationship. And that's the benefit of hiring a young lawyer instead of some old lawyer, because ideally, God willing, I'll be here to help transition you into the next generation, do their plans. And then, my firm will continue to nurture that relationship, make sure no assets are forgotten about. So that's the kind of idea that I want for Scarborough law. Beneficiary designations override a will. So your will, even though it says it goes equally to all your children, if you put a beneficiary designation on an asset, that goes according to the beneficiary designation. The big myth, a will does not avoid probate court. I know I harped on that already. Wills are just instructions to judges. That's all it is. So, what is a trust in particular? So, we can think of a trust as a box, right? The settlor is the person who creates the trust. So, they're going to be we set at the top of the box. The trustee manages what's inside of the box. The beneficiaries manage or benefit from everything inside the trust. So, the trustee manages the assets for the sake of the beneficiaries. Let me say that one more time. The trustee manages the assets for the sake of the beneficiaries. And the reason why we think of this as a box is because we want to put assets inside of the box. So if you own a home and you own a trust, the trust does not control the home until you put the home inside of the trust. Very important. That's called funding the trust. We fund a home into a trust by transferring title. So you will have to file a deed, right? General warranty, quick claim, special warranty from the house to the trustee of that trust, right? And that's the process of funding. This table here is to represent businesses. You can also put a business inside of a trust. Um, if it's LLC, it's called an assignment. If it's a corporation, you sell your stocks to that trust. Once you do that, the trustee controls everything inside of the trust. And anytime there's a distribution from your partnership LLC corporation, they pay that to the trustee. The trustee then distributes that money according to whatever terms are inside of the trust. So if you're the settlor, right? Let's say your mom and dad. You can also say you're going to be the trustees while you're alive, right? And so, and you could say you're going to be the beneficiaries as well. But when you pass, the beneficiaries are going to become your kids. And so, you can manage these assets so that they get the money from these assets when you pass in a certain way. Let's say you didn't want them to have all of the money until they were 25, or you could say a third at 25, a third at 30, a third at 35, because you think they're going to be more mature at 35. I mean, you know your kids best. The point is you can be very specific and tailor the distributions according to your wishes. This is very important with special needs children as well. Because ideally you'd always have a caretaker for them. Minor children cannot inherit assets outright. So if you pass before your minor children obtain the age of 13 or 18, the court will put a guardian of their estate over that child because they cannot manage finances themselves. All right. And no, you do not need to go to probate with the trust. This is all private. So let's say mom and dad set up what we call a revocable living trust while they're alive. They will be the settlor, the trustee, and the beneficiaries while they're alive. Mom passes. So now, mom as a settlor passes, dad is going to be now the sole trustee, right? And he'll still be the sole beneficiary as well. So he'll get the whole estate. And you can set it up so if the mom passes first, let's say she had kids from outside of the marriage, she could either say her entire portion or a portion of her half of the community property and her separate property will be retained in another trust for her extramarital kids, right? So you have a lot of customization options with the trust, and it all avoids probate. Um, yeah, it all avoids probate. I think I lost my train of thought there. What was I going to say? So the right side is a picture of a properly funded trust, right? You put the home and the business inside of the trust. Um, but yeah, this is common for, blended families is what I call it when the family has children from other marriages and you don't want to risk putting your new spouse in a bad relationship with your, prior children from a prior relationship. Um, it can help to ease your passing if you set up, these separate trusts so that your spouse is still taken care of, but also you're not in the position of your new spouse potentially disinheriting your children from a prior relationship. So it's a way to control what happens to your property when you pass, but also um, provide for these different parties. So yeah, and then if you know you have a child with special needs, you can set up a special needs trust. If your parent is getting older and they want to satisfy the requirements for Medicaid, you can set up a Medicaid asset protection trust so that way they don't have to spend down all of their money to, be eligible for Medicaid because there's a threshold of wealth that if you're above, they make you spend down in order to, before you can qualify for Medicaid. Um, and then there's just like we call them lifetime asset protection trust for minor children, where we say, either you could do it by age, like I said, 25, 30, 35, they get what the assets in the trust, or you could do it by milestone, graduating college, getting married, starting a business, all very common milestones in order to receive distributions. I don't know if you guys have seen this movie called Ultimate Gift. I know I'm going on a tangent here, but it's a great movie about a grandpa who passes and sets up this elaborate scheme for his grandchild to end up getting like this billion-dollar business at the end. It was a good movie, but that's the kind of thing you can do. You can be very creative as long as it's not illegal. And so the rest of the story is about making sure you fund the trust. So a trust does not get recorded anywhere. It does not get recorded at the county. This is something that people struggle with a lot. I struggled with this a lot when I was first learning it. A trust is a binder that literally sits on your bookshelf, like it'll just sit on your bookshelf, and when you need it, you'll just go to the bookshelf and read it. You can give copies to your successor trustees, your beneficiaries, everyone who needs to know about it, but the city doesn't need to know. The federal government doesn't need to know. It is very private. The only evidence of your trust existing will be the property title themselves. Like I said, it'll be the deed filed at the county that says, you have transferred your ownership to the trustee of this trust. And for revocable living trust, you will be the initial trustee. But when you pass, the trust will have a successor trustee in the terms of the trust that will step up and manage those assets, which avoids probate. The reason why trust avoid probate is because the trust owns the assets and the trust isn't dying. Just you as the trustee is dying, right? If the trust died or went away, then yeah, you'd have to go through probate to determine ownership of that asset. But trusts aren't living beings like you and I, and so they don't die. So the purpose of this story, but mom had a trust. The family found the binder, felt relieved. Then they learned the assets were not connected to it, right? They never went to the county, they never changed the deed. And so, on this slide, they're still on the left side. They didn't enter the right side. And so the trust isn't going to work. All right. And so this is pretty self-explanatory. A revocable living trust helps avoid probate only if the trust document is signed and assets are titled properly to the trust. B, the family knows where the binder is. C, the successor trustee is a family member. D, I am not sure. The answer is A, right? It has to be, the trust document has to be signed and assets have to be titled properly to the trust. Very important. And then you also want an inventory as part of either the trust or given to the beneficiaries. That way they know what's in the trust, right? You have to know what you own. The trust must be funded and you have to know what you own. Documents do not work unless assets are aligned. Okay, this next story, I've gotten so many calls about, like, not this, particular story, but the situation is very important. So imagine you are in charge of your parent, right? You've been taking them to their medical appointments. You've been helping them pay the bills. Let's say she's getting your parents getting social security. So, you're just logging in with with them there. You're paying their whatever they need to have paid, right? Then mom becomes incapacitated, right? Everything's still due, but now your mother can't make. So let's just say the definition of incapacitation first. The definition is you're not able to reasonably ascertain the risk involved with making a decision, right? You could think of it kind of like a child. We wouldn't say a child can consent to an action because they don't understand the secondary consequences to their actions. That's what makes you a child. A similar thing when you have a stroke and you lose that mental capacity to make a decision, you are, you know, technically you don't become incapacitated until the doctor says you are, but you can become legally incapacitated before a doctor tells you you are if you're not able to make those consent decisions. And so if that daughter does not have, let me not answer the question before. So let's say mom is alive but incapacitated. What does the daughter most likely need to act for mom financially? A copy of mom's will. B, a durable financial power of attorney. C, a death certificate. D, verbal permission from siblings. E, I'm not sure. Denise, what do you think? B is correct. A durable financial power of attorney. Um, the key to this is that a, a power of attorney, whether it's durable or medical, cannot be signed by someone who is incapacitated. So you have to do those before you need them, right? That's the hard part. Everybody puts these things off. A power of attorney, you cannot sign it without being of sound mind and body. And so, uh, for this situation in particular, she's going to have to go get a guardianship, right? And you say to do what? If she already has all the passwords of the accounts, uh, whatnot, she can maybe still provide for her mother's estate without, doing any documents. But I mean, eventually, if she has to, let's say, get real access to the bank account, um, change where a benefit is going, like let's say Social Security is sending the money to the wrong place and she wants to change anything on behalf of her mother, right? Institutions are not going to let, you just go make decisions for your parents just because it's your parent. Um, you will need a guardianship order. Like, let's say your sibling admits your parent to a nursing home, and your parent then becomes incapacitated while she's in the nursing home. You won't even be able to get her out, her or him out of that nursing home without a guardianship order, right? And that's thousands of dollars, months, right? Anytime you go in court, just think thousands of dollars. I had it months. So it's very important to get these power of attorneys in place before you need them, is my point. Another misconception about wills is it has any authority before you die. It does not. You need to die in order for a will to have authority. Uh, and so if you start naming, like, I want this person to have this, property, and you become incapacitated, no one's going to be able to access your stuff while you're still alive. This happens a lot. Like, no, you need a power of attorney that was signed prior, HIPAA authorizations, right? So you can give somebody medical power of attorney, but if you don't give them a HIPAA authorization is basically saying you allow this person to have knowledge about your medical care and, like, your prescriptions and your status. They're going to be making blind decisions, right? And if you don't sign those power of attorneys before you need them, you're going to court, right? Banks will not met, they won't deal with you. And so this last aspect of estate planning, super important as well. The children waiting at school. All right. Imagine, I don't know if you guys have children, but imagine you have this minor child and you get into a car accident today. And let's say you're a single parent and you get something happens to you. Well, who's going to take care of your child tonight? Let's say you have to go get admitted. Most people have like that secondary caregiver, maybe a grandparent or sibling who can, step up when they need it. But what kind of legal authority have you really given them? Is it just you had a conversation with them telling, or you filled out some form at the school saying this person's also allowed to pick up Timmy from school? Yeah, but what happens when Timmy needs uh to get, new uh clothes? Like, are they gonna have to pay for it out of pocket, or are they gonna be able to get your money? What if Timmy has, a need for medical prescriptions? Are you gonna be able to go pick up the medical prescriptions from the pharmacy? These things require legal authority, um, and your children may need protection tonight, right? A guard. So this is an important part. Uh, you can separate the roles of who cares for your children into two different roles. The guardian of the person will care for their day-to-day decisions, will take them to school, be allowed to pick up their medications. Uh, and the guardian of the estate manages their finances. So let's say this is pretty common with children. Let's say your child gets hurt at daycare and you win a settlement against the daycare because they were negligent in, like, caring for your child. That money is going to have to go to the guardian of the estate. It won't go to you as a parent. Um, it will have to go to a guardian of the estate because kids cannot inherit or win settlements outright. So the court will go through a whole process and create a trustee to manage this inheritance. Hopefully, you can get nominated as the trustee, but sometimes not. I mean, they might look at your credit score or whatever, they might have some type of determination to say you aren't responsible enough to care for them, whatever that case is. But you can get these documents in order now to have more control over this process. So every story I've talked about so far has had a missing link, right? The procrastinator, the couple who waited too long, what did they miss? They didn't have an inventory of their assets. So the wife was left looking for all the assets after the husband passed, and they didn't have any plans. So she's going to have to go through probate and spend thousands of dollars. And likely she didn't have thousands of dollars if she wasn't able to afford the home in the first place. The second story dealt with whether or not a will is enough. We all know now that wills are literally instructions to a judge. Nobody else is capable of enforcing a will except a judge. And so he had a different beneficiary designation on his will, right? His will said all of his assets go equally to his children. His life insurance only had one child on it. So his estate plan was not coordinated. It did not meet his intent. There's a big problem that can cause a lot of family strife. The third story was about an empty trust. Remember, you have to put the assets inside of the trust or they aren't controlled by the trust. They don't avoid probate. They aren't able to be controlled by the trustee. And you know, it's a same thing as not even having a trust in the first place for that asset. The fourth story was about the powerless daughter who was, helping her parent while she was alive, but once the parent becomes incapacitated, she no longer has authority to act on her parents' behalf with these institutions. And then the fifth story was if your child is a minor and they're waiting at school alone, just make sure you have someone in line with the correct legal authority uh, to care for that child if something were to happen to you today. And so just something to think about on your own, which missing link would affect you, you know, in your own capacity right now? Would it be not having any plan so you know when you pass, your loved ones are going through probate? Would it be that your assets aren't coordinated? When's the last time you looked at your retirement account beneficiary designation? Do you even know if your bank account has a beneficiary designation that you've used, right? Um, do you even know who you want to inherit your property when you pass? C is your trust may not be funded. Do you already have a trust, but you've come into possession of assets after you've, you know, created the trust that you've not yet titled properly into inside of the trust? Um, is it unclear authority if you become incapacitated, right? Are people going to have the legal authority to care for you? Or are they going to have to go to court and get a guardianship? Um, and then, are your children able to be protected if you don't make it home tonight? So your family will experience your preparation, not your intentions, not your promises, and not what you meant to do. My firm exists to close that gap between what you would like to happen, what authority do you need for that plan to occur, and then the make it usable. Make sure everyone knows how to use the plan, where the documents are, and make everything cohesive. Right. And you guys just by attending this webinar will know way more than people know already. So that's half the battle. Like I said, my process finds the missing links. I have a 3 meeting process if you're interested in, getting your estate plan done with me. The first one is called a life and legacy planning session. That's a 2-hour meeting. It's free for you as long as you complete the inventory, right? As long as you inventory your assets, I'll send you a link. You inventory your assets, and during that life and legacy planning session, I tell you what's going to happen to each asset if you leave your plan exactly the same. And then if you don't like the plan that you currently have, I give you the tools of you can get a trust, beneficiary, transfer on death deed for property, or will. Some people still want wills. Uh, you know, some people still want wills. You can choose the tool that you want in order to affect the plan that you want. The second meeting is called a signing ceremony to ensure your plan, docs are signed. So we design it in that first meeting. You sign your documents in that second meeting. The third meeting, I package everything up with you for you, very pretty. Uh, and then I give you the binder. In between the signing ceremony and the binder delivery, I do what's called a legacy interview. That's an opportunity for you to sit down in front of a camera, communicate your life values to, maybe your children or siblings, whoever would want to listen to it. Uh, and we take that, recording, we put it inside of your binder. And like I said, your binder sits on your bookshelf. If something were to happen to you, they pull that binder, and you never know how long it'll be after, and that your children or whoever can watch, your parents can watch that legacy interview and see what you said, and it can be very emotional, to see a message, and people can keep that a long time. So, and that's all included in the 3 meeting process. And so, if you know you want to schedule with me, just scan that QR code, or you can give me a call after this presentation, and um, I can get you scheduled as well. So, thank you. That's also my contact information, so you can either scan it or call that number. But that's it for the presentation. Do we have any other questions? Yeah, absolutely. Absolutely. My pleasure. Yeah, hopefully it was informative. I try to make it short and sweet, and I think, it covers a lot. Covers a lot. Very important information. All right, if there's no further questions, I appreciate everybody for coming, and y'all have a blessed day.